Welcome, KSLU law students. Settle down and get your notebooks ready. Today's explainer is a strict masterclass. If you are tackling question 23 on state emergency, Article 356 and its effect on federalism, you need a flawless 16-mark structure. We are going to dive deep into exactly how you must build that winning answer on your exam script.
Every high-scoring exam script must begin with this exact synopsis. Introduction, approval procedure, constitutional effects, impact on federalism, landmark precedents, and conclusion. Write this down. It is your roadmap.
Section 1. Introduction to Article 356. Make sure you write this heading in capital letters on your paper.
The Constitution of India provides for state emergency, or President's Rule, under Article 356. It is imposed when the constitutional machinery in a state fails. Okay, stop writing for a second and listen. You cannot summarize or skip this foundational definition. The absolute trigger for this provision is that specific phrase, constitutional machinery fails. The KSLU evaluator wants to see those exact words. It literally means the state government cannot carry on in accordance with the Constitution.
Moving to the grounds for proclamation under Article 356. The governor reports that the state government cannot function according to the Constitution, or the president is satisfied otherwise. Now, I want you to underline that word satisfied in your notes right now. It is historically the most contested part of this law. Why? Because it implies subjective discretion. You will impress the evaluator by showing you clearly understand that the president can act even without a governor's report, provided they are independently satisfied that the state machinery has collapsed.
Section 2. Procedure for approval. KSLU examiners actively look for clear, chronological, statutory breakdowns here. Proclamation by the president, then 2 months for parliamentary approval, extending to 6 months of validity and up to 3 years maximum extension with conditions. Mapping this exact timeline out visually on your answer script secures maximum marks. It demonstrates absolute procedural precision. You are showing them you know the strict parliamentary oversight required right at that crucial 2-month mark. Section 3. Constitutional effects of emergency. Open a new subsection here to categorize the specific consequences. First, executive and financial effects. State executive power is exercised by the president through the governor. Council of Ministers is dismissed. Parliament controls state finances. When Article 356 is invoked, understand this. The elected state executive is wiped out. The dismissal of the Council of Ministers is a drastic step, and it creates a direct, uninterrupted line of control from the center right down to the state secretariat. The governor effectively becomes the real executive authority. Next, legislative effects. State legislature may be dissolved or kept under suspension. Parliament assumes legislative powers of the state. Pay close attention here. There is a very critical difference between dissolved and suspended. Dissolved means the assembly is completely dead, right? Fresh elections must be held. Suspended simply means the assembly is in a state of suspended animation. It can be revived. Never ever confuse these two terms in your constitutional law paper. Suspending the assembly keeps the door open to restore the government if things stabilize.
Section 4. Impact on Indian federalism. This is where you demonstrate your theoretical mastery. Weakening and central dominance. It shifts power from state to center. Disturbs autonomy of states. Center directly controls state administration. Makes federal system unitary in nature. Elaborate heavily on that phrase, unitary in nature. Emergencies temporarily suspend the entire federal character of the Indian Constitution. The power shifts so heavily to the center that state autonomy is essentially stripped away. Positive aspects versus misuse of Article 356. Positive aspects. Helps maintain constitutional governance, and is used in case of a breakdown of law and order. Misuse of Article 356. Frequently used for political purposes and the dismissal of opposition governments. In your exam, command the page by drawing a strict T-chart, just like this, contrasting the positive intended law and order aspects with the harsh historical reality of dismissing opposition governments will demonstrate highly balanced legal reasoning.
Section 5. Pre-Bommai versus post-Bommai judicial position. I need absolute focus from the class right now. This is the climax of your 16-mark answer.
Pre-Bommai position, State of Rajasthan v. Union of India versus post-Bommai position, SR Bommai v. Union of India. You must explicitly introduce the shift in judicial review. These two cases completely transformed Article 356 from an absolute, unchallengeable power into a highly restricted one. State of Rajasthan v. Union of India.
court took a lenient view on center's power, held that president's satisfaction under Article 356 was largely beyond judicial review. Let's look at the brief background. Back in 1977, when the center sought to dismiss multiple state governments simultaneously, the states approached the Supreme Court. The ratio decidendi, the final verdict here, was that the subjective satisfaction of the president was essentially a political question, completely beyond review. Writing this shows the evaluator you know exactly how unchecked the center's power used to be.
S.R. Bommai versus Union of India. Supreme Court imposed limitations on misuse, established that president's rule is subject to judicial review, and majority must be tested on the floor of the House. Draw a box around this ruling in your script. It is your golden ticket. The facts. S.R. Bommai's government in Karnataka was dismissed without even a chance to prove his majority. A 9-judge constitution bench stepped in and radically changed the law. Their ratio decidendi? The president's rule is absolutely subject to judicial review, and the only place to test a government's majority is on the floor of the Legislative Assembly, not in the governor's office. Its absolute relevance to federalism is that it definitively stopped the arbitrary dismissal of state governments.
Section 6. Safeguards and Conclusion. The evaluator is always checking for a legally sound finish. Safeguards against misuse, parliamentary approval required, judicial review available, limited duration. These 3 pillars are the vital constitutional checks. They prevent the complete death of state autonomy. Parliament must debate it. The Supreme Court can strike it down if it's malafide, and it simply cannot last forever.
While Article 356 is necessary to deal with emergencies, its misuse can harm federalism. Judicial safeguards and constitutional checks ensure that it is used only in genuine cases, maintaining a balance between unity and state autonomy. This perfectly balances the unitary emergency powers needed for national integrity with the federal necessity of state autonomy. It shows the examiner you grasp the macro-constitutional picture. If political dynamics shift again, are these judicial safeguards truly enough to prevent the future misuse of Article 356 against state autonomy? I want to leave you with this provocative, critical thinking question to ponder regarding the resilience of the Indian Constitution. Master these concepts, structure your answer exactly as we've discussed, and you will dominate your paper. Class dismissed.